A lot of people say to us, I don't have a contract of employment. That's not strictly true. You might have a written contract of employment, but you will definitely have some form of verbal agreement with your employee or with your employer that says you will do a certain job, you will turn up at certain times, you will work certain days, and you will get paid a certain wage for doing so. Now, strictly speaking, under the law, that's insufficient. Because you have to have a written document which sets out the main terms and conditions of employment, the main particulars of employment. And that has to be given to staff within 2 months of them starting employment. Now, you might think, well, that's all right, 2 months, fine, we've got plenty of time, we get them in. And some people sort of say, well, until they've completed that 2 months, then we won't even give them a contract. So effectively, they're just there indefinitely. We'll use that 2 months as a bit of a trial period, and then we'll confirm them in post, is quite a common phrase that we hear, confirm them in post by giving them a contract. Very dangerous move, because effectively, as soon as that person's accepted the job with you, you have a binding contract with them. And until they've signed a written one, what you have is a verbal agreement with them. So even in that first 2 months of employment, if you don't give them a written terms and conditions that they actually sign up to, you are very much a hostage to fortune in terms of they say you agreed that verbally, you say you agreed something else verbally. So although the law says give them a contract within 2 months of them starting, we would always say your strongest negotiation period is when you are offering the job. So when you send an offer out, make sure it's in writing, make sure it's conditional on certain things such as satisfactory references, viewing original qualification documents. You will probably have something in there to do with Immigration and Asylum Act, seeing those original documents as well. But also make it conditioned on them signing the contract of employment and sending it back. Now, they don't have to send it back necessarily before they start work, but certainly you should be getting it off them on their first day signed. You are never in such a strong negotiating position with the employee as at that particular time. Particularly if your contract is going to include things like restrictions on them after they leave. Because, to be fair, which employee in their right mind after they've worked for you for 2 months is going to sign a contract that has that in if they don't have to? So if that's one of the terms that you are going to employ them on, then make sure the contract goes out with the offer letter, because if they really want the job, they will sign the contract and send it back, or they will at least pick up the phone and negotiate some of the terms of the contract with you. The law sets a minimum, which says it has to have specified particulars and express terms in it. Those terms are fairly basic. They are the name of the employer and employee, the start date, whether or not they've got any continuous employment with you, as in they may have changed role. This is a new contract to go with that role, but they've previously been employed by you continuously in some other role, or you might have bought a company and they've come in with the assets of that company. Hours, notice period, holidays, pay and pay intervals, sick pay, pension provision if there is one. That's the sort of thing. And it is quite a basic minimum document that we're talking about. Obviously, as lawyers, we would say that's not enough, because all that is telling the employee their rights. Actually, it tells them everything you're going to give them: their notice period, their pay, their holidays, how much sick pay they're going to get. It's all geared towards what the employee needs to know are their rights with you. What it doesn't really do is set out what you want them to do. So if you want things like post-termination restrictions, so they can't go off and work for a competitor and take all your clients and customers with them, then that needs to go into the contract. If you are wanting the right to be able to search lockers and desks, etc., if you want the right to be able to monitor emails and communications, that's the sort of extra information that should be going into the contracts that you put together in this day and age. The law says minimum written document within 2 months. It also says it's got to refer to rules and procedures. What do we mean by rules and procedures? We mean disciplinary and grievance. So even though the statutory procedures are going, there is still the need to refer to your company's written disciplinary and grievance procedures. So you still need to have a written disciplinary procedure and grievance procedure. What we would advocate though is the fact that those procedures themselves are not put into the contract. If you had in your contract, you would have to go to each and every employee and get them to agree a variation to that contract. Now, can you imagine how time consuming and effectively the hassle factor that's going to be for you to have to do that? What the law says is you need to refer to those procedures, i.e. where they are and who you can get copies from, etc. But you don't put the detail of the procedure as an appendix to the contract or something like that, because it is going to cause you problems if you ever needed to change chunks of it. Changes we're going to be talking about in relation to the new ACAS code aren't rocket science, so hopefully if you do have it in your contracts, you would be able to explain to somebody why you need that procedure to change in the appendix. But if it was a slightly more controversial change, you would struggle, because you would have to get each and every employee's agreement unless you had a recognised trade union you could negotiate with. And believe me, negotiating with a recognised trade union is often not anywhere near simpler than actually dealing with the employees individually either. So either way, you would have to talk to somebody to get some agreement to that. There are other areas where terms and conditions of employment come from, which you haven't even written down or put together yourselves. And these come from a variety of sources. But you have implied terms, i.e., is there an industry sector norm, maybe a start time, a finish time, a rate for apprentices, something like that, that you have implied into your terms and conditions of employment. Customer practice is the classic. You've got the employee saying, yes, but we've done this for 30 odd years, so it's customer practice that we do it this way. We'll talk about that in a minute. But these are the ones where they sneak in, the Acts of Parliament, all these massive equal pay cases that have been going on against the councils and the NHS trusts and the school dinner ladies and all that at the moment. What they are relying on is a clause that is implied into every contract of employment that you have that says people will receive equality of pay. That equality clause comes purely from the Equal Pay Act. You don't need to put it in writing because the Equal Pay Act puts it in there for you. Staff handbooks is guidance only, shouldn't form part of the contract. There have been some worrying cases in the last 12 months that say that some staff handbooks can actually be contractual and some of the policies and procedures in there can actually end up as part of the contract. The classic example that they tended to be looking at the beginning of last year was in relation to enhanced redundancy pay. If it was set out in a redundancy policy in the staff handbook, did that make it an automatic right for the employee to get that? And worryingly for us and worryingly for a lot of you out there, the courts did come back and say yes, it did actually make it a contractual right. If it was followed almost without fail each time there was a redundancy, then it starts to become a contractual right. We would say yes, staff handbooks are good, they're very good guidance for employees, they're very good guidance for managers as to what you do in particular circumstances, but they are guidance only. And therefore somewhere at the front of the handbook it should state that it is guidance only and does not form part of the contract of employment. Finally, collective agreements. This is where you have a recognised trade union and you agree with that trade union your new pay levels, for example, or salary bands, new start times or new shift allowances. If those are signed up to by the recognised trade union, then that change becomes a legally binding change in every contract of employment for the group that they represent. So you might have somebody who is negotiating a new shift allowance with you in relation to grounds staff that you might have. The union's recognised for the grounds staff, they negotiate the new rate, they ballot their members or they don't, they get the agreement from the members, they sign up to it in a written agreement to say this is the new rate, everybody's happy. What that automatically does is put that new rate into everybody's contract of employment without you having to do anything more than that. Sometimes that can be a quicker way of making sure that it actually covers a large group of employees. The classic example you may get is the employee who comes in and says, but I'm not a trade union member. The unions have negotiated this, but I'm not a member, so I haven't. If that person falls within the group that the trade union is recognised for, it goes into their contract of employment as well, whether they're a trade union member or not. So it's not an excuse for the employee to then come forward and say, I'm not a trade union member and therefore that doesn't apply to me. Because if they're in that group that's covered by that recognition agreement, then they are covered, and that change automatically goes into their contract.